Do not.
Well, then you are not a named party, so you're not consenting.
And one phrase she kept repeating like a spell: I do not recognize this court's jurisdiction. This isn't fiction. It's a real hearing, filmed in a Michigan courtroom. And what happened in the minutes that followed is why over 2.9 million people have already watched this case. This is the file. Let's open it. Ann Arbor, Michigan. A house worth approximately $1 million. The Whitlows bought the property with a mortgage. They defaulted in less than a year. From there, the repossession process began. And that's where this stops being a simple default case and turns into something much stranger. Multiple bankruptcy filings start showing up, all connected to the same address. Ms. Whitlow files 2 separate bankruptcy cases. A man living in Arizona also files for bankruptcy, listing this house in Michigan as his residential address. None of those filings stop the process, but they delay it. The plaintiff requests immediate eviction, or, at most, 11 days to vacate. If the occupant remains during any further stage of the process, she'd be required to post roughly $10,000 a month in court-ordered bond. That's the moment a woman identified as Banks, who isn't a named party in the original case, stands up to speak.
Do not.
Well, then you are not a named party, so if you're not consenting to this court's jurisdiction, sit down. You can go.
Oh, I see. So I need to.
I don't know what you need to do, but
Okay, I'm not really understanding.
This sovereign citizen squatter refused to leave a $1 million home. She walked into Judge Simpson's court smiling like she had already won. Judge Simpson wiped that smile off real fast, and what he hit her with at the end, she never saw coming.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. This is a $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
well, then you are not a named party, so if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease.
go challenge it. With who?
With Whitlow. Ms.
Then
Whitlow
you
was
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but
Notice what actually happened there, because it's simpler and more final than it looks. The judge didn't debate her theory. He didn't cite a single law to refute the sovereign citizen argument. He simply pointed out the most basic fact available. If she doesn't recognize the authority of that court, then the court has no reason to hear her at all, especially considering she wasn't even an official party to the case. 8 words. Sit down. You can go." That was the end of her participation in the hearing. The judge granted possession of the property to the plaintiff. He authorized eviction within 10 days. He set an appeal bond of $15,000 a month in case the ruling was contested. Banks later failed to pay that amount. She was no longer living at the property by the time the video was published. This case went viral for the confrontation. But what it actually documents is a pattern American judges are facing more and more often. The so-called sovereign citizen movement. People who believe that specific legal phrases, said in the right order, can cancel out a court's authority. No court in the United States has ever accepted that theory as valid. Not once. The response pattern is almost always the same as what you just saw. The judge doesn't argue the theory. He simply follows standard procedure, and the theory changes nothing about the outcome. The house was never really in dispute over ownership. It was in dispute over who could stay the longest without leaving. And in the end, a Michigan courtroom took less than a minute to answer that. Sources: Survival World. Public court footage from the 14A District Court, the Verdictly Channel.